Bye. And the next speaker, I will invite Ken Kundaya to share a few words.
Muted. Okay. Thank you, everyone. Thank you for inviting me to say a few words. Just to preface, I'm actually on the premise that I'm going to introduce Borneo Forum and then let Simon and Boyd do the brand presentation. But it looks like I've been looking at the 15 minutes. I'm going to talk about quickly introducing Borneo Forum and then also focus on the role of law, actually. That's slightly different from the original title, the role of law in climate change and environmental protection. So let me share my slides. Okay, introduction to Borneo Forum, and I'm Ken, and it's a brief commentary on the role of law and climate change. I slightly adjusted that because of the interest that's going on about this. I was going to cover more on the role of business, but then the role of law seems to be the most interesting one when all the interest in that due to the current hot topics in the state especially, which I'll touch a little bit later. Now, so Borneo Forum, by the way, as I introduction myself, I'm from Sabah. I'm from Papar, Sabah. I got a scholarship to study in the UK. I actually came to the UK to study education, but cleverly or craftily also did a double major, ended up with triple major in education, law, and history to allow me to do a law degree while doing education, qualified as a teacher, and came back to Sabah. Was doing some work in Simlaya for a year, and then I won the Chevening scholarship and did my master's degree in international law. And then further than that, went back to Sabah again. I was lecturing in Sabah for a while, and then in banking, and then again back in UK doing my further postgraduate studies in foreign direct investment. So at the moment, I'm actually in a very, very different industry, very much on fintech, financial technology, cryptos, and DeFi, they call it, decentralized finance, as a legal advisor, counsel for a multinational company, as a vice president and legal counsel. So very much so, this area of environmental law, climate change, it is not actually my main specialty, but bear with me. So Borneo Forum, let's take Borneo Forum. Borneo Forum, why did we set it up? Borneo Forum has been existing for a while before we went online when the pandemic hit. A few of us, 3 or 4 of us, decided to launch it 2019, and we are now on our 11th session in November and December with the 12th one. So Borneo Forum Limited is a non-profit, and Borneo Organization Limited is a for-profit, but based on a social enterprise model. Both are community interest companies registered in the UK. Why the UK is simply because I'm based here, and we thought it's going to be a better entity to have it in the UK as well. The vision of the Borneo Forum is that firstly, the conservation and protection of Borneo Island. That's very, very important. That's the very first vision. Secondly, to cultivate, nurture, and strengthen relationships, cooperation, and family spirits among the Borneo people, especially Sabah, Labuan, Sarawak, as well as Brunei, and the 5 regions in Kalimantan, Kaltara, Kaltim, Kalteng, Kalbar, and Kalsel, through entrepreneurship, business, cultural, and social activities. We are non-political. And then to develop Borneo sustainably, as envisaged in the UN Sustainable Development Goals. Okay, what's our mission? Our mission is to organize forums, conferences, exhibitions, and expos to build a network, particularly in Sabah and Labuan and in Sarawak and the whole Borneo, as well as with friends of Borneo all over the world. and to create opportunities for entrepreneurships and business for the people of Sabah, Labuan, Sarawak, and Borneo as a whole, and to protect, promote the rights of Borneo people, especially the indigenous people of Borneo, to train capable, clean, and trustworthy young leaders of Borneo who care for Borneo, and through training program and coaching, and to protect Borneo environment, its flora and fauna, and its biodiversity, and to find and generate funds and resources to facilitate sustainable development of Borneo. So that's how brief I'm going to talk about Borneo Forum, because I realize I've made a lot of slides on the legal aspects, the role of law instead. So as I said, I'm not a specialist in environmental law. My interest in this area became heightened ever since Boyd and Simon joined Borneo Forum as project directors, and that's really heightened my interest. It's always been there, but I'm not really focused on it because of my interest in finance and financial technology. But I'm being guided by the work of a very, very prominent judge, Supreme Court judge in the UK, Lord Canworth, CVO, and by other experts. I like to quote, just to premise this presentation, a quote by none other former justice from Malaysia, His Royal Highness Sultan Azlan Shah, back in 1997. This kind of summarizes what it is all about. Legal principles and rules help convert our knowledge of what needs to be done into binding rules that govern human behavior. Law is the bridge. Law is the bridge between scientific knowledge and political action. This is a kind of a summary of what the role of law is all about. Now, I'd like to go back briefly the development of environmental law in the last 50 years. Yeah, the most groundbreaking development was in 1972, the Stockholm Declaration. This is hugely groundbreaking. The Declaration of the United Nations Conference on Human Environment in Stockholm 1972 recognized the need to adopt measures of the protection of the environment. Okay, so this is it. This is the one that kicked it off. It first affirmed our shared responsibility to protect and improve the environment for present and future generation. And it sets out the basic principles as well, which became the foundation of modern environmental law. This is where it all started. So it's very important to know this, because what I'm trying to do here is to address the normative formation of international law. International law are developed or become formed by norms, by practices, by multilateral agreement, by declaration, slowly evolving into international law. An example of that is, for instance, slavery. The old days, no one even thinks slavery is illegal, but because of the action of few people campaigning and against it, eventually the whole world woke up and they said, this is bad. And then all the declaration against anti-slavery and then the legislations came about because of the work of these pioneers. And this is what we're doing. This is what we're doing about the environment, similarly with the anti-slavery law and after many years of development. This is how it is coming about. So this declaration is so important, made an appeal to all countries in this respect to respond to this. Government, all countries began incorporating environmental policies in the administrative legislative framework. Okay, because of the declaration, governments are following, and this is why declaration and summits and work of this nature is so important. And then, of course, 20 years later, we have the Rio Declaration. That is more precise form of principles. There's an early test on the interaction between science, law, and politics, and the global response to the threat of the ozone layer for CFC. Yeah, used widely in all refrigerations and a lot of machinery. So these are the first two development. Okay. And then two major conventions followed. 1985, the Vienna Convention on the Protection of Ozone Layer. And then in 1987, the Montreal Protocol on Ozone Depleting Substance, ODS. Okay. The significance of this further convention, they are then evolve a compliance procedure supervised by implementation committees. Okay. The approach was non-judicial and non-confrontational, but yet it established the protocols. Having said something about the conventions and efforts and declarations, we also have development from judicial intervention. Okay, the most significant case in America, this is important, the Massachusetts versus EPA, the Environmental Protection Agency, 2007. This is a very significant case that, why do I mention this very much national cases? Because we don't, other jurisdiction, especially the common law jurisdiction, refers to all these cases as a precedent, and they establish further customary law or practices, or even inspire other judges or decisions by other jurisdictions. So this is so significant, and it actually pushed President Obama a radical climate agenda on his during his presidency. It's crucial in the US-China joint announcement on climate change 2014. And this paved the road for the Paris Agreement, of course. In 2015, a very, very auspicious year in climate change law. There are two important judicial developments from very different legal angles. Okay, this is very exciting because one is a European case in The Hague called the Uganda case, very much using tort law, very, very innovative. And the other one is Pakistan, Lahore, the Lahari versus Federation of Pakistan case. We seem to think, why would a national case become so important nationally? Because these are really referred to. They are referred to by other courts, by other jurisdictions as a guide. So these two are very, very significant case law developing. I like to touch upon not only the legal aspect or the legal community, I would like to touch on the commercial, especially the financial sector as well. In 2015, the Bank of England Governor, Mark Carney, made a statement, okay, warning financial institutions of the risks and challenges of transition of carbon-free economy, okay? Okay, he said, we do not need an army of actuaries to tell us that a catastrophic impact of climate change will be felt beyond the traditional horizons of most actors, imposing a cost on future generation that the current generation has no direct incentive to fix. In other words, once climate change has become a defining issue of financial stability, it may already be too late. Why is this statement so important? It's important because they define the legal responsibilities for investment funds, corporate entities of all kinds, company directors, all the financial instruments now are being warned that the money that is spent, or the funds that's accumulated, invested in certain area, must then be conscious of the impact of those funds. It cannot be just spending those funds for deforestation, for instance. They must be accountable for their action, what those funds and capitals or hedge funds or venture capitals are going to be spent upon, and what's the impact of those funds, because those capital are such a powerful force in where the environment is going. Money speaks, money talks, and this is the significance of this statement. And this now it become repeated and referred to almost like a legal decision, funnily enough. And then, of course, we have the fantastic Paris Agreement in December 2015, already alluded to by Joe Boyd. We don't have to talk too much about this, but this is actually truly monumental achievement. It's huge. It's shocking almost. It was breathtaking in terms of the ambition and the scope of it and the speed of it's being done. Okay. Basically, the key obligation lie in the NDC, nationally determined contributions. That's very key to this whole agreement, which each party is legally required, to prepare, communicate, and maintain. The NDC is to be achieved through domestic mitigation measures. Okay, Article 4.2 of the Paris Agreement. Okay, so although the content of NDC is left to the individual states or country or nation, there's going to be a progressive improvement, but then that become very quite effective. Okay, so the NDC is the key of this Paris Agreement. Now, I have a lot more to talk about on the other aspects of the declaration, but I'd like to move on quickly. Before that, of course, the 2017, we know President Trump became president, and that was a rude awakening, a setback for us. He didn't believe it, and of course, he spent his years as a president to undo all Obama's work, and he's been issuing executive orders to undo all the previous work by President Obama. And I'm glad that now that is no longer the case, and also the undoing the agreement, the leaving of an agreement actually cannot take it until last year November, so it didn't really happen. So it's a good thing. What happened next, without being too specific. Now, having covered about the international formation of legal norms, international law, declaration, there's also a huge, massive growth in climate litigation around the world. So private individuals, companies, or group taking action against authority or companies. This is the area I'd love to explore more, because I think it is the future, the force for people to take action against. It could be authorities, could be companies, private legal action. It's developing. The law behind it is really expounding. Now, for those of you who are researchers, a good source, actually, beautifully done, called A Handbook on Climate Litigation by Professor Carl and Weller of Heidelberg University. You can find that. That is a very useful resource, where they document and archive all the litigation cases. Very important, because somebody can just have that a local lawyer that do not have a lot of experience in the area and read that and become proficient about the whole body of law in climate litigation. I will come back to that later in terms of Sabah and Borneo. Okay, there's also the UNEP ASEAN Development Bank handbook, called Comparative Climate Change Litigation Beyond the Usual Suspect, 2021, very new. Okay, this is also, it covers 30 different jurisdictions. Why am I excited about this? I'm excited about this because it is a very complex area of law, and to have a archive, a compendium, resources, a treasure trove of the legal action taken privately, it's a fantastic thing. You know, you lawyers, you can imagine if you walk into a law library and you have all the thing in one book. That's absolutely, absolutely fantastic. Now, just bringing it down quickly to Malaysia. We have already mentioned that Malaysia is very much subscribing to the Paris Agreement. In Malaysia alone, the primary legislation governing Malaysian environmental policy is the EQA 1974, Environmental Quality Act 1974. That is in need of revision and updating. It prevents pollution. And enforce action against those who cause harm to the environment. And then I'd like to touch a little bit on the Constitution of Malaysia. The Article 5 of the Federal Constitution says, no person shall be deprived of life or personal liberty save in accordance with the law. That looks a bit general. What's it got to do with the environment? Actually, this in 1996, this provision was interpreted by the Court of Appeal to include the right to live in a reasonably healthy and pollution-free environment. That is a significant. This is the Tan Teck Cheng versus Suruhanjaya Perkhidmatan Pendidikan 1996. So there you go. We have a basis for future private litigation based on the Constitution of Malaysia. I also read that the Bar Council of Malaysia has a special committee, the Bar Council Environment and Climate Change Committee. They are involved in formulating new Environmental Protection Act to replace the current EQA. They are also involved in the Wildlife Conservation Act 1910. It's about the smuggling and poaching of wildlife. And the Wildlife Conservation Act gave recognition to the current threats towards the Malaysian wildlife and introduced stricter penalties to lawbreakers. So this is quite useful, obviously. And then, having spoken about private action, there's a landmark judgment, very new, in January 2021, in the case of Taman Rimba Kiara. This is a landmark of very good news for the future, where the Court of Appeal, YB Datu Mary Lim, decided that the proposed development obtained by the developer, a joint venture, was null and void. So the whole development, the joint venture that was already agreed, was declared null and void and was stopped. And this is the kind of thing. This is the decision. The decision is a landmark, is a triumph for environmentalists, environmental cause, and the community. And no doubt, this case is going to be the basis of further private litigation going forward. In Malaysia, Borneo, as you know, pollutions, incidents, water pollution in 2020, Borneo, of course, faced with the problem of forest fire, burning, if not haze and smoke, deforestation in large scale, resulting in environmental change, massive floods. We face flooding in Sabah recently and everywhere. Yeah, plastic already. Simon covered that. Fish bombing. So the proper enforcement of environmental law is necessary to curb all these activities, because sometimes the the damage is so severe, especially the fish bombing and all that, destroy all the coral reef. It's sometimes almost irreparable or takes a long time to repair. So it's so important, without even being obvious here, to preserve our green lungs for the future generation. And this whole Heart of Borneo project, it's very important. Okay, now as I mentioned, what is the challenge in Malaysia? Although there's a lot of advancement in the legal development internationally, and there's a lot of private litigation in Malaysia. In Malaysia, private litigation is still very minimal, still lacking, so to speak. Litigation is the nature of Malaysian society, not very litigious, unless it's about election and results. We do a lot of litigation on that side, and also we are conscious of, like, how to say, we don't do that. There's a cost, of course. It's a cost involved, but we are not very litigious. And the state of the judiciary, the limited access to justice, of course, the limited environmental awareness is another thing, and the limited recognition of environmental rights. All of these are the areas that we can do a lot to raise awareness, and this is one of the forum, together with a forum, to raise awareness about environmental rights. There's a need for greater enforcement powers to the relevant authorities and harsher punishment to the polluters, to the destroyers of the environment. Okay. The environmental issues become more and more complex now. You see the recent development, and the EQA should be improved now, revised and improved and amended. Okay, lawyers especially should take public interest in litigation and give free service, pro bono basis. More so for the matters affecting basic rights, lawyers should step up and provide. Cost is a big thing, and for the lawyers to take upon cases without charging, that is a good thing. And I believe, and also the Bar Council believe, that there should be a need for a specialist court in Malaysia, also national and state level and regional level, to handle environmental cases, because it needs a very specialist knowledge. And I think that's a good way forward if we have a specialist court in Malaysia. Yes, that's about it. I think. I don't know how long I've spoken to. How long have I spoken to? For? Am I 10 minutes up? Okay, yeah, I speed it up. Now, just to conclude, there's an area of law called an area of study called green criminology, which is what I am researching now. Okay, it is a branch of criminology that involves the study of harms and crimes against the environment, including the study of environmental law and policy, the study of corporate crimes against the environment, and environmental justice from criminology perspective. Yeah, this is very important. Once this is established as a modules and a learning modules in law schools and business schools and in universities and colleges, it gives us the awareness of what we can do with the law. That's the role of law. The role of law is so important. It is the tool that makes the ordinary people have a tool to defend their belief and also to protect the environment. So thank you very much. I do have a lot more to go, but I better not deeper on the whole role of business, the carbon trade and all that. I think that's too much if I covered that for now. I think I'll conclude here. It's just a run too quickly on the international level. I still have not touched on the ASEAN level, the regional level. There is a report just published by ASEAN on the state of climate change report dated 31st of October this year. That's a significant document. I've not even touched on ASEAN Southeast Asia. I've not even gone deeply into the state level law, various environmental law. Obviously, that would be great, but it's too much material there. And thank you very much. I hope that was helpful. A very, very brief introduction to the role of law at an international level, regional level, national level, and then the local level and the individual level. Thank you very much.
Yep. Thank you very much, Ken. If you can close your share, yeah, that's great. Just while I get myself slightly organized here. Okay. Thanks very much, Ken. Honestly, you've all given us a tremendous amount to think about. It's really great, really, really great. We're over our time, that's for sure. I think that, I mean, yeah, well, anyway, we just are. So I think we can take a few questions, but shall we aim for 10 o'clock?